Hello everyone, welcome to Earth IAS. I am Amit Kumar. Dear students, in this lecture we are going to discuss previous question paper of Polity section of year 2022. And before starting this lecture, I would like to tell you that if you have any kinds of doubt or queries, you can comment in the comment box or you can mail us. This is our official mail ID earthias.enquiry@gmail.com. I would personally answer your doubts or queries as soon as possible. Now let's start. So, first question is about Government of India Act 1990. It says, in the Government of India Act 1919, the functions of provincial government were divided into reserved and transferred subjects. Right? Which of the following were treated as reserved subjects? So, if you have read this act, then you would be knowing that the subjects were divided into two categories: reserved and transferred subjects, right? And under reserved subjects, most of the important subjects were in the list, right? So, and it first is administration of justice, correct? Second says local self-government. No, actually, what was the main difference? Under reserved subject and transfer subject, most important subjects were under reserved subject, right? And less important, for example, health, education, local government, or all were under transferred subjects, and they were dealt by Indian ministers, right? So even by applying your common sense, you can answer this question, right? So local self-government, as I told you, it was in transferred subject. Next, land revenue, obviously, and lastly, police, right? So administration of justice, land revenue, and police were under reserved subject, right? So you can clearly see statement 1, 3 and 4 are correct. Now correct answer: A says 1, 2, 3, no. B says 2, 3, 4, no. C says 1, 3, 4, yes. So C is the right answer. No need to go for other option. C is the right answer. Statement 1, 3 and 4 are correct. Simple. You can check the explanation. Here is the explanation. You can pause the video and you can read. Next, if a particular area is brought under 5th schedule, you must be aware of 5th schedule. It is related with schedule areas, right? So 5th schedule of the constitution, which one of the following statement best reflects the consequence of it, right? So it says this would prevent the transfer of land of tribal people to non-tribal people. Obviously, under this 5th schedule, it can be prohibited, right? That the transfer of tribal land can be prohibited to non-tribal people. This provision is correct. This would be the right answer, but read other option. B says this would create a local self-government body in that area. No, actually it is a matter of Panchayati Raj, right? Not 5th schedule. Next, this would convert that area into union territory. One thing is missing here: union territory, right? So nothing like that. D says the state having such area would be declared a special category state. No. So A is the right answer of this question. Here is the explanation. You can read. As I told you that it is related with, means 5th schedule is related with or deals with administration and control of scheduled areas and scheduled tribes, right? And in any state except those in 6th schedule. And 6th schedule includes which of the or how many states? You can comment in the comment box. How many states are included in 6th schedule? You can comment in the comment box, right? Rest of is here. Next, with reference to writs, right? As you would be knowing, under Article 32 and 226. Under Article 32, Supreme Court can issue writs. Under Article 226, High Courts can issue writs. So it says with reference to writs issued by the courts in India. It has said courts in India, not Supreme Court or High Court, right? Consider the following statements. So, mandamus, right? Tell me how many types of writs can be issued by the Supreme Court or High Court, right? In the comment box. How many types of writs are there? You can comment in the comment box. So, mandamus, it says, it simply means what? We command, right? So, it simply says, mandamus will not lie against a private organization unless it is entrusted with a public duty. Obviously, this is correct. It can be issued only against public bodies, public authorities. Right? If a company or private organization, right, is private and it is not performing any public duty, then mandamus cannot be issued against a private organization. This is correct. But if a private organization is performing public duty even for a temporary period, right, then mandamus can be issued, right, against a private body, right, or private organization. Second statement says mandamus will not lie against a company even though it may be a government company. Wrong. Mandamus can be issued against a government company, right? For example, PSUs. Mandamus can be issued against PSUs, right? Next, any public-minded person can be a petitioner to move the court to obtain writ of quo warranto, right? So quo warranto means by what right, or you can say by what order. Simple, right? So this is also correct. Means this provision or writ of quo warranto accept or exempts, you can say exempts the status of locus standi. Means any public spirited person can move to the court for the issue of quo warranto, right? So this statement is correct. Now you can clearly see statement 1 and 3 are correct. Correct option A says 1 and 3 no, 1 and 2 no, B says 2 and 3 no, C says 1 and 3 only. So C is the right answer, not D. So you can clearly see option C is the right answer. Statement 1 and 3 are correct, right? Here is the explanation, right? You can pause the video and you can read. Next, consider the following statements. First statement says a bill amending the constitution requires prior recommendation of the President of India. No. If a bill is related with constitutional amendment, then prior recommendation of President is not required. So this statement is wrong. Second, when a constitution amendment bill is presented to the President of India, it is obligatory for the President of India to give his or her assent. Obviously, correct. If it is a constitutional amendment bill and it is presented before the President, then it is obligatory for the President to give his or her assent, right? Third statement, a constitution amendment bill must be passed by Lok Sabha and Rajya Sabha by a special majority. Obviously, it requires a special majority, not simple majority. And again, there is no provision for joint sitting. Yes, one more thing you should, and you would be knowing that in case of money bill or constitutional amendment bill, there is no provision for joint sitting. Both bill, constitutional amendment bill and money bill, should be passed separately in both the houses, right? No provision of joint sitting. And again, constitutional amendment bill should be passed by a special majority in both the houses, not by simple majority. So statement third is also correct. Now correct option A says 1 and 2 no, B says 2 and 3. So B is the right answer. No need to go for C or D. So you can clearly see option B is the right answer. Statement 2 and 3 are correct, right? Now fifth question. Here is the explanation, you can read. With reference to Deputy Speaker of Lok Sabha, consider the following statements, right? This is related with Deputy Speaker of Lok Sabha. It says, as per the rules of procedure and conduct of business in the Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. Yes, This is correct, right? So the date of election of deputy speaker is fixed by the speaker, right? Next, there is a mandatory provision that election of a candidate as deputy speaker of Lok Sabha shall be from either principal opposition party or the ruling party. It says mandatory provision. Listen, there is no mandatory provision like that. Generally or conventionally, it has been seen that the deputy speaker is from opposition party, or sometimes this is not followed. But it is a parliamentary convention, not mandatory convention. Next, the deputy speaker has the same powers of the speaker when presiding over the sitting of the houses, and no appeal lies against his rulings. Obviously, while performing duty by the deputy speaker as speaker of Lok Sabha, he has same power just like speaker of Lok Sabha, right? And no appeal lies against him, right? Against his rulings. For the statement, the well-established parliamentary practice regarding appointment of deputy speaker is that the motion is moved by speaker and duty seconded by the prime minister, right? No, there is nothing or no practice like that. So simply you can see statement 1 and 3 are correct. So choose the correct option. A says 1 and 3. So A is the right answer. No need to go for B, C or D. You can clearly see that option A is correct and statement 1 and 3 are correct. Now sixth question. Here is the explanation. You can read the explanation. Next, sixth question. It says, which of the following is or are exclusive powers of Lok Sabha? Exclusive powers of Lok Sabha means in which of the following Lok Sabha is more powerful, or you can say it has exclusive power. Generally, in general sense, Lok Sabha and Rajya Sabha are equal, but in some cases, Lok Sabha is more powerful than Rajya Sabha, and in special circumstances, Rajya Sabha is more powerful than Lok Sabha. For example, in case of money bill, Lok Sabha is more powerful. In case of creating any all India service, Rajya Sabha is more powerful, right? So first it says to ratify declaration of emergency. No, in or while declaring emergency, both houses, Lok Sabha and Rajya Sabha, has equal powers. It is not exclusive power of Lok Sabha. Second, to pass a motion of no confidence against the Council of Ministers. Obviously, why? Because as you do knowing, Council of Ministers headed by Prime Minister, right? Or Council of Ministers are directly responsible to the Lok Sabha, and that's why a no confidence motion, whenever a motion of no confidence is introduced, it should be introduced in the Lok Sabha, not in the Rajya Sabha. So it is exclusive power of Lok Sabha, right? To impeach the President of India. No, again both Lok Sabha and Rajya Sabha has same power. The impeachment procedure can be introduced whether it is Lok Sabha or Rajya Sabha, in either house. So you can clearly see only statement 2 is correct, right? Now correct answer, A says 1 and 2, no, B says 2 only. So B is the right answer. No need to go for C or D. Here is the explanation. You can read. Next, consider the following statements. The Constitution of India classifies ministers into 4 ranks: cabinet minister, minister of state with independent charge, minister of state with, and deputy minister. Listen, it has been, or ministers has been classified for the purpose of better governance, better administration. The Constitution does not classify ministers into these categories. So this statement is wrong. Constitution does not classify, right? Next, the total number of ministers in the union government, including prime minister, shall not exceed 15%. Shall not exceed 15% of total number of members in the Lok Sabha. Yes, this statement is correct. Means the total number of ministers cannot be more than 15% of total number of seats in the Lok Sabha, right? And by which amendment it was done? It was 91st Constitutional Amendment Act. Right? Now answer B. Which year this Constitutional Amendment Act was passed? Which year? You can comment in the comment box. So you can clearly see only statement 2 is correct. Right? Only statement 2 is correct. And correct answer is A says 1 only, no. B says 2 only, yes. So B is the right answer. No need to go for C or D. Here is the explanation, as I told you. Now, 8th question. Consider the following statements. Pursuant to the report of N. Sanyal Committee, right? You should remember this committee. Contempt of Court Act 1971 was passed. Statement is correct. And you do knowing that when you have, or if you have read Article 19, then you must be knowing that contempt of court, right, can be issued or restricted. It can restrict the freedom of speech and expression, right? And you do knowing there are two types of contempt: civil and criminal, right? Under Contempt of Court Act, section 2B and section 2C, right? 2 subclause B and 2 subclause C, right? No need to discuss in very detail. Next, the Constitution of India empowers Supreme Court and High Court to punish for contempt of court of themselves, right? So this statement is also correct. Next, the Constitution of India defines civil contempt and criminal contempt. No, as I told you, it has been defined under Contempt of Court Act under section 2 subclause B and under section 2 subclause C. There is provision for civil contempt and criminal contempt, right? And punishment is up to imprisonment up to 6 months or fine of rupees 2000 or both, in both the cases. Next, in India, the parliament is vested with the power to make laws on contempt of court. Correct. Right? Now, correct answer. A says 1 and 2, no. B says 1, 2 and 4. So you can clearly see statement 1, 2 and 4 are correct. So B is the right answer. No need to go for C or D. B is the right answer. Right? Statement 1, 2 and 4 are correct. Here is the explanation. You can read. Now, 9th question. So, 9th question says, with reference to India, consider the following statements. Government law officers and legal firms, right? Legal firms are recognized as advocates. Listen. Law officers can be recognized as advocates as per Advocate Act, right? But law firms are not regarded as or recognized as advocates. So this statement here it is incorrect again. But corporate lawyers and patent attorneys are excluded from recognition of as advocates. Wrong statement, right? As I told you, legal firms are not recognized as advocates, and law officers or any person having law degree and who has been registered in bar council, right, then that person is recognized or recognized as advocates. Simple. And that is the difference between lawyer and advocate. If you are having a degree of law, you are a lawyer, you are not an advocate. But if you have or your name has been enrolled in bar council, then and you are allowed to practice in the court of law, then you are an advocate. Right? That is the simple difference between lawyer and advocate. Next, bar council have power to lay down the rules relating to legal education and recognition of law colleges. Obviously, this is right. Bar council has such power. So this statement is correct. You can clearly see only statement 2 is correct. Right? So option A says 1 only, no. B says 2 only. So B is the right answer. No need to go for C or D. Here is the explanation. You can read. Right? As I told you, that as per Advocate Act 1961, right, only individuals enrolled in a state bar council, right, are recognized as advocate, and a person who is a law graduate having law degree is known as lawyer. So a lawyer is not every time an advocate, but an advocate is every time a lawyer, because that person holds a degree of law. That is the minute difference, and rest of the things are here, you can read. Next, Attorney General of India and Solicitor General of India are the only officers of government who are allowed to participate in the meetings of Parliament of India. Listen, Attorney General of India is allowed to participate in the meeting of Parliament of India without any voting right. Right, Parliament of India means whether it is Lok Sabha or Rajya Sabha, he can participate in the meetings, but he is not allowed to vote. But Solicitor General is not allowed to participate in either house. Right, so this statement is wrong. Next, according to the Constitution of India, the Attorney General of India submits his resignation when the government which appointed him resigns. No, actually, it is a constitutional post. So, an Attorney General of India works under the pleasure of the President, not under the pleasure of government. It means if the government has resigned, it does not mean that the Attorney General will resign. He remains in his office or post. So you can clearly see both the statements are incorrect. Right? A says 1 only no, B says 2 only no, C says both no, D says D. Actually, it is D. Right? Neither 1 nor 2. So D is the right answer of this question. D is the right answer. You can pause the video and you can read the explanation. Next, with reference to anti-defection law in India, you must be knowing about anti-defection law, right? This law was passed to check the defection of political leaders, like political legislators, for example, MLAs, MPs, from one party to another, right? Consider the following statements. Now, so the law specifies that a nominated legislator, for example, a nominated MP or MLA, cannot join any political party within 6 months of being appointed to the house. Listen, here UPSC has played. It says within 6 months, right? But the actual law is, it says after 6 months. After 6 months. Means if a legislator has been nominated by a, right, then he cannot join a political party after 6 months of being appointed to the house. For example, person X has been nominated as a legislator to Rajya Sabha, right? And what happens that after 6 months from being nominated, right, to that house, then this legislator will be disqualified, right? So this statement is wrong, because as I told you, the law is after 6 months, means after 6 months a nominated legislator is not allowed to join a political party, but this statement says within 6 months. That is contradictory. Next, the law does not provide any time frame within which the presiding officer has to decide a defection case, right? So this is correct, but in different cases Supreme Court has said that it should, means the presiding officer, right, should decide a matter of defection case at within 3 months, right? So this is correct constitutionally or legally, this is correct, but in different judgments Supreme Court has said that it should be decided by the presiding officer within 3 months. So you can clearly see only statement 2 is correct. Now correct option, A says 1 only no, B says 2 only. So B is the right answer, no need to go for C or D. Here is the explanation. right? 10th schedule does not, just let me explain. Second statement, 10th schedule does not provide any time frame within which the presiding officer has to decide a defection case, correct? Because but in Supreme Court in this, right, Kesham Meghchandra Singh case versus Speaker Manipur Legislative Assembly 2020 observed that disqualification petition should be ideally be decided within 3 months. Though law does not, means 10th schedule does not prescribe the fixed time limit, but Supreme Court in this case held that it should be decided within 3 months. But this is not a binding statutory provision, right? Next, with reference to T board in India, consider the following statements. T board is a statutory board, right? Actually it is a T board. The T board is a statutory body, obviously under T Act. It is T board under T Act, or has been established under T Act, and that's why it is a statutory body. Second, it is a regulatory body attached to the Ministry of Agriculture and Farmers Welfare. No, listen, do not apply your common sense every time. You will think that tea is an agri product, right, and it is related with Ministry of Agriculture. No, it is related with Ministry of Commerce, right, not Ministry of Agriculture. Next, T board's head office is situated in Bangalore. No, actually it is situated in Kolkata. Next, the board has overseas offices at Dubai and Moscow. This is correct. So you can clearly see only statement 1 and 4 are correct. Now, correct option: A says 1 and 3, no. B says 2 and 4, no. C says 3 and 4, no. D says 1 and 4. So, right answer is D, option D. Statement 1 and 4 are correct. Here is the explanation. You can pause the video and you can read. Now, 13th question. Consider the following statements. The India Sanitation Coalition is a platform to promote sustainable sanitation and is funded by the Government of India and the World Health Organization. Listen, half of the statement is correct here, right? That the India Sanitation Coalition is a platform to promote sustainable sanitation, but it is not funded by Government of India or World Health Organization. Actually, it is, and you can say, arm of Federation of Indian Chamber of Commerce, in short FICCI, right? Next, the National Institute of Urban Affairs is an apex body of the Ministry of Housing and Urban Affairs in Government of India and provides innovative solution to address the challenges of urban India, right? So this is correct. So you can clearly see statement 1 is incorrect and statement 2 is correct. Now choose the correct option. A says 1 only, no. B says 2 only. So B is the right answer. B is the right answer. You can check the explanation. Right, here is the explanation. As I told you that this body is an arm of Federation of Chamber of Commerce, FICCI, right, and it, Government of India or WHO does not fund it. Next, in India, what is the role of Coal Controllers Organization? Right, CCO. It says CCO is the major source of coal statistics in Government of India. Obviously, this is correct, right? It provides major statistical or data to Government of India. Next, it monitors progress of development of captive coal or lignite blocks. If you have read geography, you would be knowing about different types of coals: peat, lignite, bituminous, anthracite. Right? No need to discuss here. So also this is correct. It monitors the progress and development of captive coal or lignite blocks. Next, it hears any objection of government's notification relating to acquisition of coal bearing areas. Also correct. Last, it ensures that coal mining companies deliver the coal to end users in prescribed time. No, this is not the function or role of CCO. So only statement 1, 2 and 3 are correct. Now check the correct answer. Option A says 1, 2 and 3. Obviously option A is the right answer. Statement 1, 2 and 3 are correct. No need to go for B, C or D. Right? Here is the explanation. You can read. Now last question of the day. So it says, in India, which one of the following complies? Information on industrial disputes, closures, retrenchment and lays off in factories employing workers. So very straightforward question. No, you shouldn't have any kind of if or but. Simply what? A says Central Statistics Office. No. B says Department of Promotion of Industry and Internal Trade. Here you can confuse, but have patience. C says Labor Bureau. Yes, Labor Bureau, right? Compiles information of industrial disputes, closures, retrenchment, and layoff in factories employing workers. That is the function of Labor Bureau. No need to go for B or D. B is the sorry C is the right answer. Right? Labor Bureau. Here is the explanation. You can read. So that's all for now. We will meet in another lecture. Till then, thank you.